Hello everyone, this is Sherelle Suggs and this is my attorney-client fee agreement. This is only an academic exercise created by a student. This is not a real retainer agreement or a real case. Okay. Hi Ms. Victim, I am Sherelle Suggs, the paralegal for attorney Barry Barrister, and I'll be going over the attorney-client fee agreement with you today. So for number one, we have our conditions, and this pretty much states that the attorney will have no obligation to provide legal services to you until you return a signed copy of this agreement. This is a part of the ABA rules, which is Rule 1.5 fees, and it states that rate of the fee and expenses for which the client will be responsible shall be communicated to the client, preferably in writing, before or within a reasonable time after commencing the representation. So we move on to number two, scope of representation, and this pretty much states that the attorney is going to be hired by you to provide legal services in the assault and battery matter that you have against Tammy Tortfeasor. And we have here that incident occurred at Earthen Fair grocery store on September 2nd of 2017. And the attorney will take reasonable steps to keep you informed of the progress, and he will respond to your inquiries that you have. Then we move on to number three, client duties. So this states that you will agree to be truthful to Mr. Barrister, and you will also cooperate. By truthful, we mean if there's anything that you haven't told us yet or that you're skeptical about telling us, you pretty much just need to tell us anyways, so we can represent you in the best way that we can. This also states that you abide by this agreement to pay attorney bills on time and keep the attorney advised of your address, telephone number, and your whereabouts, just in case we need to get in contact with you with something. So then we move on to number fees and costs, which is pretty much the most important part of this agreement. This states that the attorney shall receive 30% of any recovery, settlement offers, or awards. So the 30% will come after all expenses are deducted, and expenses include, but they are not limited to, court costs, investigations, research, or extraordinary administrative expenses, which consist of photocopying and depositions and things of that sort. So I have two different examples that go over pretty much the fees. And for example one, I have, if the court awards you $65,000 and the attorney has spent $16,000 in expense, that leaves $49,000. And will then take out their contingency fee of 30%, which is $14,700, and you subtract that from the $49,000, and that will leave you, Ms. Victim, with $34,300. Or then we have example two, which is pretty much the same, just with different numbers, and it states that if the court awards you with $170,000, the attorney has spent $80,000 in expenses, that leaves $90,000 left. The firm will take out their 30% contingency fee, which is $27,000. You'll subtract that from the $90,000, and that leaves you with $63,000. I'll give you some time to go over this agreement, and if you have any questions, feel free to ask. Thank you.